Let's discuss patient-paramedic relationships or caregiver-patient relationships. Um, Medical or personal information, medical history, assessment findings, treatments uh, will not be released to third party without express permission of the patient or the legal guardian. It falls under confidentiality. Um, However, there are specific circumstances under which a patient's confidential information may be released without their express permission. Um, well, first and foremost is the patient consents to the release of his records. That's the easiest way to release them. Is the patient signs a release and hands it to you, and you keep that on file, and you are allowed to release records to the patient or of the patients to whomever they deem that they can be released to. Other medical care providers have need to know. So the doctors and nurses at the hospital need to know what care was given to them in the pre-hospital setting. So you're going to release those records to the doctors. Yes, you gave a verbal report, but they also have access to the written report. EMS is required by law to release records by court order or by subpoena in the event of a lawsuit, that kind of thing. The agency receives a court order subpoena. It is good practice for that person to consult with the lawyer, the county's lawyer, or the services lawyer to make sure that this is a valid and reasonable subpoena. They have more insight into the legalities of that part. And then there are third-party billing requirements. EMS agencies that bill patients for services, it's generally necessary to release certain confidential information to receive reimbursement from private insurance companies, Medicare, Medicaid, that kind of thing. If possible, the agency should get that, and that's usually the signature you get on your EPCR. When you drop off the patient at the hospital, they sign the screen on the iPad or the tablet or whatever. That is giving consent to giving the information to the third party. The law provides penalties for breach of confidentiality with improper release of information may result in the paramedic for defamation, libel, or slander, breach of confidentiality, or invasion of privacy. If found guilty, the paramedic may be responsible for paying monetary damages to the patient. It's one more reason not to mess with it. HIPAA, everybody's favorite thing, the Health Insurance Portability and Accountability Act, or HIPAA. Change the methods that EMS providers use to file insurance Medicare payments also adds important new layers of privacy protection for EMS patients. The privacy protections provide, among other things, that all EMS employees should be trained in HIPAA compliance. Furthermore, EMS providers must develop administrative, electronic, and physical barriers to unauthorized disclosure of patients' protected health information. Disclosures of information, except for the purposes of treatment, obtaining payment for services, healthcare operations, and disclosures mandated by or permitted by law, must be pre-authorized in writing. That means the patient must pre-authorize that release in written form, and that written form has to be kept on file with the release of these records. HIPAA requires providers to post notices in prominent places advising patients of their privacy rights and provides both civil and serious criminal penalties for violations of that privacy. Patients are given the right to inspect and copy their health records, restrict use and disclosure of their individual identifiable health information, amend their health records, require a provider to communicate with them confidentially, and account for disclosures of their protected health information except for treatment, payment, healthcare operations, and legally required reporting purposes. Requirements of HIPAA are detailed, and every EMS provider must become familiar with them. So we very much need to be careful with HIPAA. A HIPAA violation could be as much as talking about a patient or a call in a restaurant and releasing any kind of identifiable remarks that somebody would know that that patient, who that patient might be. Defamation is defined as a person makes intentional false communication and injures another person's reputation or good name. A patient can sue for defamation if the paramedic or a provider communicates an untrue statement about the patient's character, reputation, with legal privilege or consent, or without legal privilege or consent. Defamation can occur in written form or through verbal statements. Libel is the act of injuring a person's character, name, or reputation by false statements in writing or mass media with malicious intent or reckless disregard for the falsity of the statements. Allegations of libel can be avoided by completing an accurate, professional, and confidential patient care report. Do not use slang and value-loaded words or phrases in your report. For example, do not refer to a patient as stupid or use any derogatory race-based term. Many states consider the patient record part of the public record. Never write anything on it that could be considered libelous. Leave your opinions out of it. If it is a quote by somebody, then it needs to be in quotes, and if it is needed in the report for whatever reason, it should be who said it and in quotation marks. Again, if it doesn't contribute or have anything to do with the patient's treatment or condition, then it doesn't need to be in there anyway. Slander is the act of injuring a patient's character, name, or reputation by false or malicious statements spoken with malicious intent or disregard for falsity of those statements. Again, so this is the same thing as libel, except this is just speaking it. And you don't care if they're false or if there's no proof or anything like that. Allegation of slander can be avoided by limiting oral reporting of patients' condition to appropriate personnel only. So keeping your radio report very short and concise, and then your bedside report should be as confidential as possible, as a closed room, only people who are in direct care present, and that kind of thing. Many places record the radio traffic between the hospital and the EMS services. In addition, scanners in some places where they're using older technology and your frequencies are not encoded are common. So radio transmission is, like I said, short, concise, to the point. Should not be saying anything about the patient, their character, or anything like that over the air. The invasion of privacy would be the release of confidential information without legal justification regarding the patient's private life, exposes the patient to ridicule, notoriety, or embarrassment. So basically, if you take a picture of a patient and you post it on social media and somebody can identify who that patient is, and it puts them in a very difficult position, so to speak, or compromising position, that could be an invasion of privacy because you had direct patient care or you were privy to information that got you to that picture. Or releasing information of you found this person at a noted establishment of ill repute, so to speak, or doing something or somewhere where they should not have been, but this is not openly or widely known, and you release that to the public, and now you are guilty of invasion of privacy. particularly in the case of, let's see, many EMS employers have social media policies that govern the use of social media when on duty or representing the employer. Violating these policies may lead to one's loss of one's job, particularly in the case of non-government employers. First Amendment free speech protections are unlikely to apply. And we're seeing that play out in society right now. You need to be extremely careful with phones and cameras and recording devices of any kind that are not part of your job. It's easiest just to leave them in your pockets until you're home or back at your station, in your room, and all your work is complete. Consent, by law, we must have a patient's consent before we can treat them. Consent is granting permission to treat. More accurately, it is the granting of permission to touch. Walking in, introducing yourself. Hi, my name is Roman. I'll be your paramedic today. How can I help you? May I assess you if they're alert and oriented enough to know what you're doing. Along with that, you must get a patient's consent before you can provide medical care and or transport. You also patient must be competent to give or withhold consent. Now, that is defined as a competent adult is one who is lucid, able to make an informed decision about medical care. They understand your questions and recommendations. They understand the implications of their decisions made about their medical care. There is no absolute test for determining competency, but again, keep the following factors in mind. What's the patient's mental status? What's their ability to respond to questions? Statements regarding the patient's competency from family or friends. Are they normal? Is this how they usually react? That kind of thing. Evidence impairment from drugs or alcohol, or indications of shock or hypoxia. Are they altered in any way? Does it seem like they're altered? Is family reporting that they are altered? Is this normal for the patient? Are they understanding you? That kind of thing. Again, your documentation will play out in this as well. A conscious, competent patient have the right to decide what medical care to accept and what that they want to refuse. Consent can be, for consent to be legally valid, it must be informed, or consent given based on full disclosure of information. The nature of illness or injury, the recommended treatments, the risks, dangers, and benefits of said treatment, alternative treatment possibilities if there are any, and the risks, dangers, and benefits of those, and the dangers of refusing treatment and or transport. Informed consent must be obtained from every competent adult before treatment may be initiated. Conscious, competent adults may revoke consent at any time during care or transport. In most states, patients must be 18 years of age or older to withhold consent, and generally a parent or a legal guardian must give informed consent or treatment of a child can begin. There are some exceptions to those rules that we'll hit on here after a bit. Expressed consent is most common. The person directly grants permission to treat verbally, non-verbally, or in writing. The act of patient requesting an ambulance is considered an expression of a desire to be treated. Just because the patient consents to ride to the hospital does not mean that he has consented to all treatments. They may not want the initiation of an IV or the administration of medications. Consent from the patient does not always need to be granted verbally. It may be expressed by allowing care to be rendered. If they tell you no, you explain, then it becomes informed, and then they still say no, then you stop. If they consent, then at that point, then expressed becomes informed, and you are covered. Again, if they refuse treatment, again, risks, benefits, explain to them what the treatment is for, and then documentation of that consent or refusal. Unconscious patients are not able to give consent when treating them, or any patient who requires intervention, but is mentally, physically, or emotionally unable to grant consent. Treatment then depends on implied consent, or some people call it the emergency doctrine. You would assume that that patient would want treatment. Any rational, competent adult would want treatment at that time, and you go off of that with implied consent. Occasionally, a court order will a court will order patients to undergo treatment, even if they may not want it. This is called involuntary consent. This may, whether this applies to us or not, this may be something that is in the Department of Corrections or in a jail, county jail, something like that. They are normally held with for mental health evaluations, or is directed by law enforcement personnel who have the patient under arrest. Also used on occasion to force patients to undergo treatment for a disease that threatens the community at large, tuberculosis, that kind of thing, where they are quarantined. Law enforcement personnel often accompany patients who are undergoing court-ordered treatments just to ensure that they are complying with the court order. Consent issues arise when a paramedic is called by law enforcement officials to seek treatment, to treat a sick or injured prisoner or arrestee. The officer tells you that they have a legal authority to give consent to treat for the patient simply because the patient is in police custody. However, a competent adult in police custody does not necessarily lose the right to make medical decisions for himself. In fact, many prisoners may have successfully sued healthcare providers for rendering treatment without consent. Generally, forced treatment is limited to emergency treatment necessary to save life or limb, or treatment ordered by the court. Be sure you're familiar with your local protocols and laws on these issues. Yes, by all means, make sure that you are speaking to your service directors, your administrators, and clarifying this, especially if it comes up. Generally, if the person that is under arrest or being detained for whatever reason, if that's just a laceration or something like that, doesn't necessarily need stitches or anything like that, and they tell me they don't want anything done, if you can't talk them into at least just a dressing over the wound, then you're kind of stuck with what you get. You don't have to put it on if they don't want it. Just take it case by case. Most of the time they're pretty willing to accept treatment, that I've noticed. When special consideration would be in the case of a minor, depending on state law, usually under the age of 18, consent should be gotten from a parent or a legal guardian or court-appointed custodian. Same is true for a mentally incompetent adult. How we're going to know this would be your adults that are in group homes, that are mentally disabled or handicapped in some way, and just ask. Many of them will tell you that they're under they have a not necessarily a power of attorney, but they have a custodian. There is a custodian involved, or if they live in a group home, the caregivers in the home know that there is a custodial permission that must be gained, or what have you. They know the ins and outs of that person's history. If that person can't be located, and if the child or mentally incompetent adult is suffering from an apparent life-threatening injury or illness, treatment may be rendered under implied consent. It's implied that they would want what needs to be done to be done. An emancipated minor is considered an adult. This person is under the age of 18, who is married, pregnant, a parent, a member of the armed services, or financially independent and living away from home. As an adult, an emancipated minor may legally give informed consent Anyone else under the age of 18 may not be able to, and that's different in different locations. Know your local laws. Again, look that up. I've actually been told many different things on the nursing side, saying that a minor that is a parent cannot consent to their own treatment, but they consent to their kids. That the parent of the minor has to give consent. It's convoluted and confusing. So this is something that needs to be clarified, and I will look into that a little bit further here locally anyway, and see what differences we have. Now, as with anything else, a competent adult or emancipated minor may withdraw consent for treatment at any time. The refusal must be informed, because if they're competent, you must inform them of all the risks. The best example is a diabetic. You have given them D50. They are back to A&O times 3. They're answering questions. They are understanding what you're saying to them. They know the risks. They know the benefits. They've been here before, and they're refusing treatment and refusing to go to the hospital, even though this may be their third low of the day. They can refuse that treatment. In fact, they can walk out of your ambulance as you pull in the garage. They can say, nope, I'm not going into the hospital. I know what, and you inform them of the risks and benefits, and they still say, nope, not going in the hospital. Okay, sign this, and they walk away. If they do not sign it, again, documentation, thorough and accurate of attempting to stop them, or attempting to give them the risks and benefits, and letting them know what they may be running into. Here's an example of a release of liability. You have spoken to them, you have told them, they've read this, so they sign it. You can witness it. Your partner can witness it. Usually a law enforcement or something like that is what I like to have witness my refusals. That way they can't come back and say my partner is covering my butt. And then the date and time that it is signed. And then document that the form is signed within the documentation. That way everybody's on the same page and everything fits in a nice little package. Refusal of service may be sure the patient is legally permitted to refuse care, must be a competent adult or an emancipated minor, because they are considered to be a competent, or if they're a competent emancipated minor, because they are considered an adult. Make multiple and sincere attempts to convince the patient to accept care. I usually give them three tries. I'll explain to them. I'll try to convince them 3 different times. If they don't go, then we move on. Have them sign the form. Enlist the help of others. I've contacted family and friends, of wives, mothers, fathers, kids, to try and convince people to get care taken, and they have still refused care. I've fully informed them of the implications of their decision, the potential risks. Consult with online medical direction. Most at least make the attempt. Let them know that the patient is refusing. Have the patient, a disinterested witness, sign the release from liability form. A disinterested witness would be somebody who has nothing to gain either way, if there is one available, and move on. Advise the patient that they can always call you back, and that you'll come. We can't refuse treatment just because they refuse to go with us to the hospital. Attempt to get the patient's family or friends to stay with the patient if necessary, or to bring them in. The patient may refuse to go with you, but they may go to the hospital with the family. Document the entire situation thoroughly on patient care report. Obviously, we want to make sure that that's all covered and documented as accurately as possible. Have your partner read over it and make sure that everything in there is what happened and nothing was left out or nothing was added. It's always good to have that second set of eyes. Problem patients. These are the patients we're having trouble with calming down, or otherwise you get your intoxicated patients. They can present with medical legal dilemma. They've drank too much or they've overdosed, and they are concerned family members have called. You find the patient is alert and oriented, denying that they've taken the medications, refusing to give consent for treatment transport. Try to develop some rapport with the patient. If he continues to refuse, remains alert and oriented, refusal form should be completed, witnessed by the police or somebody else who's there. If the patient will not sign the form, have a police officer or family member sign that you, in fact, did attempt to convince them to go. Patient is still absolutely refusing. Verbally, and so on, refuse the care. However, the situation becomes more dangerous. You have reason to suspect that the patient has tried to injure themselves. Police officers or family members consider legal measures to force a patient to receive treatment. So that's out of our hands, but we can call in law enforcement if they're not already there. If we suspect it, call them in, get their perspective on it. If they have a drug recognition expert on duty or somebody that can come take a look at this patient and either confirm your suspicions or refute them, whichever the case may be. It's just another verification for you guys, because that's going to be in a report as well. Intoxicated people pose a problem. Every effort should be made to encourage them to accept care and transport to the hospital. If they refuse, explain to them just as you would any other patient. However, to determine the patient cannot understand the nature of his illness or the consequences, they may not be able to refuse treatment. Involve law enforcement at this point. If the patient is competent to make such a decision, have them sign a refusal form. You may run into law enforcement that does not want to get involved in that. If they don't agree with you that that patient is not competent, that they think the patient is competent enough, again, have them sign have them sign the refusal form as a witness then at that time, and document the fact that the law enforcement did not agree or did not feel that the patient needed to be taken into protective custody and forced into treatment. Always document. And then you've got your ill or injured minor with no adult available to provide consent or medical treatment. If you can't reach them by phone or anything else like that, I have called parents, I've called grandparents from scenes, explain the situation, explain that they either need to go to the hospital or they were welcome, they're welcome to come to my location and pick up the patient, that kind of thing. If they want to refuse at that time, if they're not available, then we take them to the hospital. There's got to be somebody responsible for the adult or for the child, you would think. However, older teenagers do spend a lot of time at home alone or over at friends' houses or whatever, while parents are at work and unreachable. That's something there that needs to be addressed as well. Usually taking them to the hospital kind of helps relieve you of any responsibility or any risk to your license. You're always going to attempt to develop that trust and rapport. This is where, we got to develop that rapport with a multitude of different patients from all walks of life. Refusal forms completed and witnessed by the police officer. If it's dangerous, police and law enforcement should consider legal measures. We can only suggest it unless we are officers ourselves. The conversation with the patient and refusal witnessed by a disinterested third party. We kind of all beat that up. Boundary issues, professional boundaries. Ethical and societal limits to interactions between paramedics or other healthcare personnel and patients that they serve. Crossing these professional boundaries can result in breaching of our responsibilities. These are the dangerous areas. Being tired, fatigued can lead to problems like medication errors, poor decision making, vehicle crashes. We aren't open to seeing the problem for what it could potentially be. We're not using a foresight. We just want to get back to bed, sign the paper, whatever. Being seduced, in this instance, not in a sexual sense necessarily, but being led away from one's principles, ethics, faith, and allegiances. This is a sexual relationship between a patient and healthcare is definitely unethical and must be avoided. There are other temptations, though. Money, food, items of value, drugs may make an otherwise honorable person change depending on the situation they're in, they may change their thoughts. The mental and physical demands of EMS work, including the isolation, can sometimes lead to addictive behavior and lapses in judgment. Being gone from your home for 48 hours at a time, and then when you get home, your significant other or family are now gone for extended period, whether either they went on a vacation that you weren't able to go on or a trip to see family that you weren't able to go on. Something like that tends to cause issues, and then can lead to lapses in judgment and lead to distancing of the family unit as a whole. Being unprepared, the motto of the Boy Scouts, always be prepared. It's also a functional tenet of the EMS. You must be prepared for your job. Being unprepared, you're not ready to take care of patients, much less yourself. Well rested, have the proper equipment, make sure your truck is stocked, stuff like that. Always want to make sure you start out ready to go and prepared for what the day may bring. Abandonment. The termination of paramedic-patient relationship without providing for a continuation of care while still needed and desired by the patient. So you start treatment on somebody and you walk away and you don't come back without making sure that patient is still receiving treatment and the patient still wanting or needing treatment. A paramedic who has initiated advanced life support should not turn over the patient to an EMT or an AEMT for transport. Unfortunately, our scopes of practice are different enough that even though AEMT is considered an advanced life support provider, they are not as advanced as the paramedic. They are very much limited in their scope, whereas the paramedic generally is not, and there is a defined difference there. So ALS patients, when started care with an EMT, need to stay, or with a paramedic, need to stay with a paramedic. Abandonment can occur at any point during the patient contact, including in the field, in the hospital, ER. Physically leaving the patient unattended, even for a short time, could be grounds for abandonment. If they are outside of your sight, outside of your care, and something happens, and you have not turned over care, you have not given report, you have not done any of that, and something happens, you may now find yourself also guilty of abandonment. Assault and battery. Assault is the unlawful placing of a person in apprehension of immediate bodily harm without his consent. And battery is the unlawful touching of another individual without his consent. Excuse me. On assault, your patient states that he is scared of needles and refuses to let you start an IV, and then you show him an IV catheter and bring it towards him as if you're going to start an IV. That is considered assault. You have put him in fear of bodily harm, immediate bodily harm. He is in apprehension of immediately bodily harm. You may not have touched him with it, so this is assault at that time. It's a threat, essentially. Battery is the unlawful touching of another individual without his consent. Once you start that IV, that's battery. You have now, and this has been successfully sued in both criminal and civil context. So if they tell you no, explain. They still tell you no, don't even bring it out unless, if you already have it out, that's one thing. But without their consent and telling them what you're going to do, just be careful. False imprisonment is the intentional and unjustified detention of a person without his consent or other legal authority, may result in civil or criminal liability. So if you transport them without consent or restrained without proper justification or authority, you've now committed false imprisonment, and you can be sued. Again, it's like assault and battery. A charge of false imprisonment can be avoided by obtaining appropriate consent. This particular problem comes with psychiatric patients in most cases. You can avoid allegations of false imprisonment by having a law enforcement officer apprehend the patient and accompany you to the hospital. If they are in police custody, it is no longer false imprisonment. If nobody's available, you should attempt to consult medical direction and carefully judge the risks of false imprisonment against the benefits of detaining and treating the patient. You should determine whether medical treatment has immediate necessary or whether the patient poses a threat to himself or the public when you are making the decision to treat and transport. Reasonable force, the minimum amount of force necessary to ensure a patient does not cause injury to himself, you, or others. The use of excessive force can result in liability for the paramedic. Force used as punishment is considered assault and battery. Now, mind you, it is up to the patient or the plaintiff to prove that it was excessive force. So if you are using the necessary, reasonable force, the minimum amount necessary, and you're not escalating, then you're only escalating as needed, documenting accordingly. It makes it very difficult to prove unless you just flat exceeded what you needed to do and overreacted. Use of restraints may be indicated for a combative patient or patients at altered mental status that are non-purposeful movements, or they are otherwise altered and trying to remove IVs and stuff like that, and it's not that they are necessarily alert and oriented and just refusing, that these are the patients that are a head injury or something like that, and they're just reaching and grabbing things. You may need to put soft restraints on these folks. Restraints need to conform to your local protocols because these are what you trained under, and this is what your medical director has allowed. So be acutely aware of what is in your local protocols. Restraining devices could be straps around the wrists and ankles, around the torso. Could be a jacket type restraint or a restraining blanket. Use the least amount of force to safely control the patient while causing him the least amount of discomfort or potential for harm. Be careful with the way you restrain a patient. The positional asphyxia and restraint asphyxia, things like that, are things that we need to keep in mind. You see them crossing the arms in this picture. You need to be sure that those restraints are not going to slip on the cot and potentially come up around the neck or pose any other risks to asphyxia or choking or anything like that. And as always, we don't want to cause any more harm than necessary. Not even harm than necessary. We don't want to cause any. We want to do no additional harm. During the patient transport, we need to maintain the same level of care as was initiated on scene. Emergency vehicle operations, be familiar with state and local laws. We've already discussed that several times. Patient choice of destination and insurance company protocols. So that is okay to an extent, but you have to go to the most appropriate facility. So if where they want to go does not offer the services that they need, you can go elsewhere as long as it is within your response area. I don't know what everybody's insurance protocols are, nor do I really care to know what all the insurance company protocols are. My priority is to my patient and getting them to the proper facility. Again, facility selection is based on patient request, patient need, and facility capability. So if they request a facility and it does not have their needs and they're not capable of caring for that patient, I'm not going to that facility. I'm going to go to the facility that will meet their needs and has the capabilities of meeting their needs to ensure that their level of care is maintained.